family law consequences of the same-sex union is my theme for today. The research was carried out within the framework of the Central European Professors Network, coordinated by the Ferenc Mádl Institute of Comparative Law. The main reason for choosing this theme is the recent Serbian draft on same-sex union. I'm going to start with a short introduction to comparative law on same-sex union in European countries. Regulation of the same-sex union differs in European countries. There are three main concepts. One concept is registered partnership, for instance, Slovenia, Hungary, Czech Republic. Second is same-sex marriage, for instance, Netherlands, Belgium, Sweden, Denmark, Finland, Norway, Spain, Portugal, Germany, France, England and Wales, Switzerland, Ireland, over 20 countries. The third concept is de facto civil partnership, which does not require any formalities. In some countries, parallelism of concepts exists, registered partnership and de facto partnership as well, for instance, in Croatia and Slovenia. However, there are few countries without any legislation on same-sex union, for instance, Russia and Bosnia and Herzegovina in our region. Some countries, for instance, Sweden, has started with regulation of the legal effects of a same-sex union by widening the scope of particular existing acts to same-sex cohabitants. The Act on Homosexual Cohabiting Act was passed in Sweden in 1987 and had one single provision. If two persons live together in a homosexual relationship, what applies in relation to cohabitants in the following enactment shall also apply to homosexual cohabitants. After that, Sweden had passed the Registered Partnership Act in 1994, and from 2009, it is possible for same-sex couples to conclude marriage. They have gender-neutral marriage act. The history of Sweden legislation shows step-by-step approach to the regulation of same-sex couples. The concept of registered partnership is accepted in a number of European countries, but this concept is not uniform. The concept differs considering legal effects, conclusion, and dissolution of the registered partnership. These concepts were accepted in laws on registered partnership prior to acceptance of same-sex marriage. Thus, there were two groups of laws. One group of countries stipulated legal effects which are very similar or identical to legal effects of marriage. The conclusion and dissolution of the registered partnership was also similar to dissolution of marriage. For instance, it was like that in Sweden, Denmark, Finland, Norway, Germany. In the other group, legal effects differ to legal effects of marriage, especially in personal relations between partners, in partner-child relationship, and inheritance. For instance, France, England, and Wales. The competent organ for dissolution of the partnership was the administrative organ and not the court. That was in France. At this moment, in Serbia, the draft act on same-sex union is in the preparation. If this law would be passed, it would be almost 35 years after the first law on same-sex couple was passed. The draft act regulates two types of same-sex union: registered same-sex union and de facto same-sex union. So parallelism of concept exists, similar to solution, for instance, in Croatia and Slovenia. Registered same-sex union is defined as a union of family life of two same-sex persons, which is concluded by competent organ. Not registered, de facto same-sex union is defined as a union of family life of two sex persons, which is not concluded by competent organ. The union has legal effects only if there are no impediments for its conclusion and it lasts for 3 years. Now I'm going to talk about conclusion of same-sex union. Same-sex union is concluded by affirmative and uniform statements of two same-sex persons of majority age in order to realize the cohabitation. They give their statements of will before the organ having jurisdiction. The competent organ is registrar. Statement of will should be free. Same-sex union may not be concluded if one of the persons is unable to reason, if they are of a different sex, if one of the persons is less than 18 years of age, if one of persons is married or lives in registered same-sex union, if persons are blood relatives in a straight line, if persons are brothers or sisters, half-brothers or half-sisters, uncle and nephew, aunt and niece, or same-sex children of brothers and sisters, or same-sex children of half-brothers or half-sisters. A relationship based on adoptive relationship, is an impediment for conclusion of same-sex union in the same way as blood relationship. Same-sex union may not be concluded between in-law relatives in the first degree of the straight line. There are small differences between impediments for marriage conclusion and for the conclusion of the same-sex union. Difference exists in connection with impediment of guardianship, as guardianship is marriage impediment but is not stipulated as impediment for conclusion of the same-sex union. The explanation why guardianship is not one of the impediments for conclusion of the same-sex union is in the fact, I suppose, that same-sex union is not possible to conclude before persons are 18 years of age, so guardianship cannot exist between two persons who want to conclude same-sex union. This is possible for marriage, as marriage might be concluded if persons is 16 years of age and get court permission. The persons who are unable to reason cannot conclude same-sex union, so guardianship in this situation is not relevant. Persons who have intention to conclude same-sex union are to submit an oral or written request for conclusion same-sex union to the municipality registrar. With the request, they are to submit evidence on the important facts for conclusion of same-sex union. The registrar sets the date when the marriage is to be concluded in agreement with persons who have intention to conclude same-sex union. Same-sex union is to be concluded before the registrar in a solemn manner and in a room specially designated for this purpose. The registrar may exceptionally allow for a same-sex union to be concluded in another venue if there are justified reasons for doing so. The future spouses, two witnesses, and the future same-sex partners, two witnesses, and the registrar are to be present at the conclusion of same-sex union. Any person having legal capacity may be a witness to the conclusion of same-sex union. Ceremony of the conclusion of same-sex union commences by establishing the identity of the future partners and the registrar's report that they acceded to marriage conclusion and that all requirements for the validity of their same-sex union have been met. When the registrar determines that there are no objections to the report, she is to inform the future partners of the rights and duties of same-sex union and ask each partner individually if he or she agrees to conclude same-sex union. After that, the registrar pronounces the same-sex union concluded. The registrar, after that, enters same-sex union into the register of same-sex union. And now, how the same-sex union can be terminated. Same-sex union is terminated by the death of a partner, proclaiming missing persons to be dead, by annulment or by cancellation or break. Same-sex union can be cancelled in the court proceedings or exceptionally by the register. Each spouse has the right, each spouse, but also each same-sex partner, has the right to court cancellation of same-sex union by action or by agreement. If the relations are seriously and permanently disturbed, or if the same-sex union cannot be realized, the termination is by an action. If it is on agreement, the agreement of the partners must include a written agreement on the division of community property. It is stipulated in the draft that exceptionally, a same-sex union can be cancelled by giving consensual statements of will to the register. This is possible under two conditions. One, if the same-sex union does not, if in the same-sex union does not live minor child, and if partners do not have community property. It has to be mentioned that condition concerning minor child is not particularly relevant, as in most cases there is no issue of parental right after termination of same-sex union, as only one of partners should be a parent of minor child according to Serbian law. So this condition should be or might be abandoned in this draft. Now I'm going to talk about legal effects of same-sex union and particularly family law legal effects. Personal effects are similar to the personal effects of marriage. Same-sex partners consensually and jointly decide on all important matters for their life together. Same-sex partners have right to protection of privacy of their family life and right to mutual cooperation. Same-sex partners have a duty to help each other and to care and give help in the care of illness. Upon concluding a same-sex union, partners may agree on their surnames. They might decide that each of them keeps his or her surname. Both of them take the surname of one of them as a mutual surname. Both of them take both surnames. Each of them adds the surname of other partner to his or hers. Comparing the possibilities stipulated for spouses about their surname after marriage, it could be noticed that same-sex partners do not have a possibility that just one of them add the surname of the other partner. This is understandable, as in marriage, this possibility is the one which women choose mostly. And if same-sex union is concerned, there is no gender difference, as in marriage. Some personal legal effects stipulated for spouses are not stipulated for same-sex partners. For instance, spouses are free to decide independently from each other on their profession and work. Spouses determine the place of their residence and decide on managing the joint household consensually. In addition, affinity is not established between the partner and his or her partner's relatives. Another family law effect is maintenance or support. Maintenance is the right and duty of partners in same-sex union. But what has to be said, and I don't have a real explanation of this fact, the effect of same-sex union in this union, according to the Draft Act, there is no maintenance. This is difficult to understand. Why so? Having in mind that partners in registered same-sex union, but also spouses and partners in non-marital or extramarital cohabitation do have right and duty of maintenance after the termination of their legal relationship. So I must say I don't understand why they missed maintenance for de facto same-sex union. Another legal effect of same-sex union concerns their property. Partners might have separate and community property, identically to spouses and heterosexual partners in non-marital cohabitation. The property that the partners have acquired through work during living together in same-sex union is their community property, as well income from that property. The property acquired by using intellectual property rights during living together in same-sex union is community property as well. Income from community property acquired through work is community property. The property acquired in games of chance is community property unless the partner who won the premium invested in his/her separate property in the game. The rights of the partners on community property has to be registered on the name of both partners with undetermined shares. It is to be considered that the entry has been made for both partners even when only one partner is entered, unless a ground for the entry is written agreement between partners. It is to be considered that the partners have divided their community property if both partners are entered as co-owners of the determined shares into the public record of rights on immovable property. It is stipulated that the partner may not dispose of his/her share in undivided community property, nor may be burdened with the legal operations intervened. It has to be noticed that if community property is divided, it becomes co-ownership, as community property is undivided by definition. So it is, for me, not not understandable why we have in the draft law this stipulation about undivided community. Besides property as a legal right and duty, also for same-sex partners, it is possible to conclude the contract, and so the contract on property is available. And maybe a little bit about separate property. Separate property is property that a partner acquires before concluding a same-sex union, as well as property that the partner acquires during same-sex union by the division of community property or by inheritance, gift, or other legal operation whereby exclusively rights are acquired. Each partner independently manages and disposes of his/her separate property. If during same-sex union the value of the separate property of one partner considerably increases, the other partner has the right to a share in such property in proportion to his contribution. If during same-sex union the value of the separate property of one spouse slightly increases, the other partner has the right to a pecuniary claim in proportion to his contribution. Also, each partner is liable for his/her personal obligations undertaken before or after the conclusion of same-sex union with his/her separate property, as well as his/her share in community property. For the obligations that one partner undertakes in order to satisfy needs of same-sex union, both partners are jointly and severally liable. A partner who has settled a joint obligation from his or her separate property has the right to reimbursement from other parents. And how they can regulate their property rights. They might regulate property relations regarding their existing or future property. A contract on property is concluded in the form of solemnized notarial document. Public notary is under the obligation to warn the parties that by this contract the legal regime of community property is excluded. A property contract pertaining to immovable property is to be entered into the public record of rights on immovable property. So this is about legal effects between same-sex partners, and this draft also stipulated legal effect of same-sex union on a child. And the draft text stipulates rights and duties between same-sex partner and the child of the other partner. A partner in same-sex union has a duty to maintenance the child of the other partner, if a child does not have relatives who have a duty of maintenance, or if they lack sufficient means for maintenance. The duty to maintain a child of the other partner exists even if the union ceased by death, if the cohabitation existed until death. If same-sex union ceased by annulment or by cancellation, a partner's duty to maintain a child of the other partner terminates. A partner in same-sex union who is not a child's parent has right to make decisions on necessary and urgent acts in interest of the child where there is a danger to health and life of a child. This partner who made the decision has an obligation to inform the child's parent immediately. In addition, a partner who is not a child's parent might make the day-to-day decisions about the child in agreement with the child's parent in the best interest of a child. If a same-sex union ceases, the child has the right to maintain personal relations with the ex-partner of the parent, but this right may be limited by a court decision when that is in the best interest of the child. It could be concluded that same-sex partners have wider scope of rights than step-parents. Step-parents do not have any parental right except right and duty to maintenance, according to the family law. The child does have the right to personal relationship to step-parent, but only if she is particularly close with him or her. It seems that during writing the draft, it is forgotten to have in mind that the child would have another legal parent who has parental rights. This parent has rights in urgent situation before the same-sex partner. Okay. Another legal effect of same-sex union is effect on domestic violence. Members of the family who enjoy protection from family violence are partner, ex-partner, and the child of one of the partners. In comparison to the definition of members of the family who enjoy protection from family violence according to Family Act, the Act on Same-Sex Union is restrictive. According to Family Act, members of the family are spouses or former spouses, children, parents, and other blood relatives, in-law or adoptive relatives, and persons related by foster care, persons who live or have lived in the same family household, cohabitees or former cohabitees, persons who have been or still are in a mutual emotional or sexual relation or have a common child, or the child is to be born although they have never lived in the same family household. For me, it is not clear what draft act excludes relatives of the same-sex partners, except a child, and persons who are in mutual emotional or sexual relations, as the violence might occur between these persons regardless of their sex and regardless if they concluded same-sex union or not. According to the Act on Biomedically Assisted Fertilizations from 2017, exceptionally, the right to fertility treatment by biomedically assisted fertilization procedure is entitled to an adult and legally capable woman living alone. So this means that in practice it would be possible for the woman in the same-sex union to use biomedical procedures if they claim that they live alone. This would be easy, especially if the union is de facto one, as there is no registration and no evidence of existing. Thus, even the act of the same-sex union does not include reproductive rights and availability of biomedical technologies to same-sex partners. In practice, this could happen. The Act on Biomedically Assisted Fertilization, on the other hand, does not regulate surrogate motherhood. That means that same-sex men do not have a possibility to become parents, not theoretically and not not in practice. This draft of same-sex union also regulates legal effects according to laws besides family law. This is about inheritance rights. Same-sex partner has inheritance rights in the same way as a spouse. But a same-sex partner in de facto union does not have inheritance rights, which is similar to the position of heterosexual partner in non-marital cohabitation. Also, in health law, the partner has a right to information about the illness and the treatment of illness and to participate in decision-making on the medical treatment of the partner who is ill. If the partner is incapable to give consent to medical treatment, the other partner has equal rights and duties as spouse. If one of the partners are in hospital, the other partner has visitation rights in the same way as spouse. Partners in same-sex union have the same rights as spouses in criminal proceedings. The partner who is in jail has the right to receive passes from his partner and to visitation rights as spouse. They also have equal status as spouses in tax law, pension law, labor law, acquiring nationality, health insurance law, social protection law, including child protection law, tort law, etc. So, this is somebody is interrupting. I'm sorry. This is about the conclusion, termination, and legal effects of same-sex union according to the draft law. Now I'm going to conclude with some remarks and to say something about other possibilities for regulation the same-sex union. First, it could be said that Serbian draft might be classified on the group of laws which regulate registered same-sex union with legal effects which are similar to legal effects of marriage. Entering and dissolution of same-sex union is similar to concluding marriage and to divorce as well. This is so when comparing conditions for conclusion same-sex union marriage, as well as comparing grounds for divorce and grounds for dissolution same-sex union, as well as the procedure for conclusion and for termination, same-sex marriage and divorce. In my opinion, it might be a better solution for Serbian contemporary situation, having in mind social circumstances and accepted views in the population, to start with regulation of the same-sex union as an institution which differs from marriage. For instance, in some countries, jurisdiction for registration and dissolution of registered partnership has court. For instance, that was in France, which differs from concluding the marriage. Having in mind different concepts of the same-sex union, we would suggest that Serbia start with some differences in the procedure for concluding same-sex union and marriage. For instance, it could be abandoned the condition for witnesses to be present, to abandon solemn form and possibility to register partnership outside the registered office. For the dissolution of the same-sex union, the proposal would be to stipulate register as an organ with jurisdiction instead of the court in the all situation and not only exceptionally. For now, exceptional situation is if the same-sex union does not have minor child living with them and if partners do not have community property. We propose to stipulate two ways of dissolution, by mutual agreement and by unilateral demand, without stipulation of the grounds as for divorce, which is now stipulated like that. the jurisdiction to decide on legal effects of termination of same-sex union, as is it for divorce, should have court. These changes of the draft would make considerable differences between same-sex union and marriage. In a way, how is same-sex union regulated by draft law? The only difference between same-sex union and marriage is in the term which is used. But in fact, same-sex union is equal as marriage in concluding ceremony, termination, and legal effects, except adoption and artificial reproductive technology. It seems the draft makes parallel between same-sex union and heterosexual partnership in this way. Same-sex union is parallel to marriage, and de facto, same-sex union is parallel to non-marital cohabitation. And at the end, I would like to stress that when family relations are concerned, it is easier for community to accept new institutions to take step-by-step approach in the regulation. So, in Serbia, it would be better, in my opinion, to start with the law similar to laws which existed prior to this in force now in countries which first regulate same-sex union decades ago. For instance, it would be useful to check maybe Slovenian law, which was in force before the one which is in force now. This is law from 2005. The differences in social circumstances in particular country is the reasons why European Court for Human Rights accepts wide margin of appreciation when makes decision in family law matters. This aspect seems to be acceptable in European and international law and institutions, considering the regulation of same-sex union in Serbia. To start with regulation of the same-sex union with the considerable differences to marriage, but to protect personal and property rights of the same-sex partners. I suppose this would also be the way to avoid constitutional considerations, as it would be clear enough that same-sex union is not marriage. Thank you for the attention.